Essentially, in our field, if there is a negative workplace consequence, and Eric, feel free to correct me, jump in if you feel there's something to add here. If you have a negative workplace consequence, one of the questions that helps determine if it's a claim or not was, in a very simplified way, and this is not the true statement of the law, if that negative workplace consequence was motivated, at least in part, by membership in a protected class, that could then be a claim. So you'll have, I always make jokes about being Irish, of Irish descent, right?
Yeah.
If somebody walks into work tomorrow and says, Vince, I hate your face, you're done here, legal. Somebody walks into work tomorrow and says, Vince, I hate your Irish American face, illegal, claim, right? The gist of the equal opportunity aggressor claim is that when you bring your discrimination claim, it's an affirmative defense wherein the employer, the defendant, is saying, hey, that person, the bad actor that you're bringing this claim against, you're saying that he or she is doing something negative, causing a negative workplace consequence because of your membership in a protected class. However, funny story, that person is horrible to everyone. So it's not tied to a protected class. And this is often, I've heard this referred to as the devil wears Prada defense, right? She's not racist. She's not sexist. She's just bad. And it's a legal thing to be bad. There is no law that says an employer can't be a monster.
Right. Or a bad boss, just
bad boss,
or obnoxious, impatient, right? Otherwise, of course, the floodgates would open, right? Everyone would be suing. A lot of people would be suing their bosses, because they're
Oh, can you imagine?
Yes.
So when I pick cases, and when you used to pick cases, when you were on the plaintiff side,
sure.
At least for me, this is something I think about sometimes. It is, as my clientele became higher end, this became more of an issue for me because middle managers aren't allowed to be as bad because they've got a lot of people above them watching. But as you get into the C-suite, you find, you find people without a lot of checks upon their power. You find some legitimate sociopaths. We'll be honest, right? There's some people you're just like, whew, that gentleman, whew, right?
How do they skip over karma, right? How did karma miss them? And they're, doing so wonderfully, material. Yeah. But I hear you right to your point, huh? There's some people that definitely are a little crazy. I mean, Steve Jobs was known, right, to be a very, very hard person to work for, arguably a terrible boss to everyone, like you said. So interesting, yeah. So your thoughts are that you are in favor of the defense because do you think it upholds the integrity of like that a claim should truly be based on differential treatment and not just universally poor treatment? Or
so I'm not a fan of the defense. It's one of the banes of my existence. So in some sense, you're correct. Like I do fundamentally believe we are here to fight discrimination, sexual harassment, retaliation.
Sure.
And when someone comes in and they just have a bad boss, I'll be frank, my attitude is, I'm so sorry. That's not a case we're interested in. That's not what my firm exists to contend with. There are not really laws to contend with that. And I do believe to some extent, like Steve Jobs, tremendous example, bad boss. Avoid a lot of results, right? And it's hard to say if society can just forego all of those results. I don't know. The utilitarian argument for happiness in the world says maybe it could, but I don't know, right? So I do believe that does, to your point, as you said it, so beautifully said, it protects the integrity of our field, right? We do actually need some form of discrimination to be in play. But my real issue is that I consider it, I run into it. I would say between 5 and 10% of my caseload, I look at those cases and I say, do I think this is in play? How concerned am I about this with this defendant? And it's usually a defendant who is known or has notoriety or is somewhat famous. And in those situations, you would think those people, because they're known, wouldn't make this defense,
Mhm.
but they
Yeah.
often seem to relish it. You know,
Hmm.
um, the
Yes.
I'm trying to think of like a universally bad. I guess Steve Jobs. Steve Jobs would have relished
Yeah.
that reputation,
Right.
right? And
Sure.
you do find that, and I do think, wrapping this up, I think it's a compelling narrative. I think
Hmm.
there's a lot of juries and certain demographics in juries who say, yeah, bad boss. I don't believe it's discrimination though. And
Hmm.
that is something that keeps me up at night when I'm 60,
Yeah.
70, $80,000 deep in a case
Sure.
that's going to trial. And that is something that I see coming from the depositions. They're just going to be like, yeah, yeah, no,
Hmm.
that's a bad guy. That's a bad guy. Not racist,
Yeah.
but he's a bad
Right.
guy.
No,
I
sexist,
worry
no.
about it. So I want to hear your thoughts.
Yeah, yeah. No, those are actually great, Vince. All great points there. Seriously. I mean, and the interesting thing is that, my views on this issue have changed over the years because, as you know, I do compliance, right? So I do a lot of proactive, preemptive work. I try to help companies to follow the federal, state, and city laws on discrimination or anti-discrimination, anti-harassment, wage and hour issues. When they make mistakes, whether intentional or not, I try to get them to, come around, let's resolve this, and then let's do better moving forward. But I also do some defense work, where sometimes clients come to me after they didn't have certain protections in place and they're being sued. So I'll say that this defense, I used to be really in favor of it because of all the reasons you said, in terms of like that the law protects and based on protected class. And if it just protected you from having a bad boss who is rude to everybody, then the floodgates of litigation would be wide open, and my clients would never sleep at night. And my clients, couldn't hire a brilliant maverick who, I heard this phrase from actually one of my clients describing one of their colleagues who's an equal opportunity offender, sort of, and they said, IQ through the roof, EQ through the basement. The emotional quotient is just not there. The how to interact with people in a mature, socially conscious, emotionally mature way, non-existent. But brilliant, innovative, can build apps that build apps that build apps, all that kind of
Yeah.
stuff. So I used this defense. I believed in this defense when I had a client who was accused of gender discrimination, and the other side kept, pointing out all these rude conversations and snaps and judgments. And I said, he's rude like that to everybody. His nephew works at the company, and he's super rude to him. He tried to be rude to me, and I told him we can't talk this way. But he's impatient, he's impetuous, he's rude, all the things you're saying. So the reason I started to change my views on it is because as you know, as I do this work, I suppose in the true sense of the word, if that's really the situation going on there, that the person is just a difficult personality and we difficult, to you, an Irish American, to me, a Jewish person, regardless of our traits, I understand the point, right? I think what I find though, and what I caution my clients about when the company or the company's in-house counsel wants to use this defense is that a lot of times, these offenders, aggressors, assholes, if you will, right, and they're lashing out out of anger and resentment, and often there are some implicit bias, there's a biases in there against so that the against women or against older workers or disabled workers. So what you find is that if you really dig deep into some of the commentary and the snap judgments and harshness, it takes on a different tone, let's say with African American women in the workplace than white men, right? So when I've done internal investigations in interviews and talked to witnesses and I'll ask them about it and they'll say, yeah, so and so, John Smith and a jerk to everyone, but it's different with us, with the women. It feels like it's more demeaning, or it's more belittling, or it's more of a you don't know what you're doing, little lady. So I've seen this happen where the company gets too into that defense. Eventually, the person makes harsh comments that have a racial undertone to them, and they call somebody something they shouldn't have said, and suddenly all the bias part comes out. So then the plaintiff says, you've got this toxic workplace, the verbal abuse, the psychological abuse. And they once also said, like, you're a cheap bastard, Eric, and I happen to be Jewish, and that's a stereotype, So that's, I think, why I think the defense, in its purest form, is valid, but in the way the world works, it tends to lose some of its momentum. It tends to fall apart, sort of.
I love what you're saying. I agree with
Hmm.
it. I do have
Hmm.
a point to make.
Sure. Yeah.
So I agree with everything you're saying in terms of the implicit bias. I believe in implicit bias. I believe in microaggressions.
Hmm.
The issue for me is
Hmm.
that is a battle of inches. That is,
Hmm. Yeah.
that is a, it's not even a knife fight. It's a razor blade fight in a
Hmm.
tight alley. And
Yes.
as a
True.
plaintiff's attorney,
Hmm.
you know, you don't want to be in the razor blade fight in a tight alley. You want to be
Sure.
lobbing artillery shells with the bigger gun, being
Yeah.
very like, because we have so much invested in the case, right? Like
Hmm.
our investment, our attorney's hours in, hundreds of attorney
Hmm.
hours, tens
Hmm.
upon tens, if
Sure.
not hundreds of thousands of dollars in a case. So at the point where you're trying to convince a jury of peers
Hmm.
about
Hmm.
implicit bias, that is a
Hmm.
complex and subtle narrative, and we'll do it,
Yeah. Hmm.
but probably that was not how the case started out. Probably the case started out as a very clear narrative. That's why we took it. We said, hey, we believe in our heart of hearts, we can help this person. We can invest
Hmm.
freely in this case. We can pour our heart and soul into this case. We believe we can help, right? And if you're
Hmm.
down at trial time to,
Yeah.
okay, he is bad, but we think he's
Hmm.
bad because of implicit bias to this particular individual. And, and,
Hmm.
and if I can, Eric, let me just give a quick. So you mentioned how black women are treated, right? There's the trope of the angry black woman, a racist trope. And I always give the
Yes.
example of like, okay, you got a CEO get in the coffee line, and some black female employee gets in line ahead of him. He thinks he cut her off. But because he believes implicitly, an implicit bias in the trope of the angry black woman, he doesn't say anything there. Where if
Right.
he had addressed it with her, she'd have an opportunity to say, oh, my bad. I didn't mean to cut you off, boss. And there wouldn't be a festering issue. And she'll
Hmm.
never know that happened.
Right.
But
Hmm.
now for the rest of the time he's going around, he thinks she cut him off and he didn't address it because of his implicit bias, right? It's insidious.
Hmm.
And how will she
Yes.
ever come back from that? So everything you're saying is true and right and good. And I'm ashamed. I'm ashamed that you did a better job giving voice to it because I'm looking at it as dollars and cents. And that's a little
Yes.
bit ugly. But I have to do that because if I
Hmm.
don't, my firm won't be here next year.
Of
But
course. Yeah. Right.
but I love what you're saying. And I love that it's coming from a compliance and defense attorney. It warms my
Hmm.
heart. It really, really
No, thank
does.
you, man. It's interesting, right? We really kind of, I think, define if somebody were to know that we were both on this show today and they knew the topics in advance, they might assume, oh, Vince is probably very against employment. Well, Eric's very, for it. Eric's probably against non-competes. Vince is probably, I'm sorry, Eric is for non-competes. Vince is against. But I think
Yep.
we show that, when issues are given good thought, um, it kind of different sides of it. And I definitely see your point. If you're like going to take on a case from the perspective of how winnable it is, then yeah, that's a race with an argument to make to a jury. And if some of that jury has not experienced implicit bias, they're like, oh, that's just a new buzzword. It's not. It's not, right? I think from my perspective, it's funny. So I can look at it like from satiric and the ethical and the moral implications, and but when I get down to business, also, how for you the business concern might be that the plaintiff is putting too much stock in the fact that there's implicit bias that'll come out, and that the person was meaner to them because of their Muslim background or mean in a different way. I think that on my side of the fence, what I worry about is when a company might hire me to investigate because they have in-house business counsel who doesn't do employment law, and then they say, "Oh, no, 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 right? I checked it out and I talked to people, and they all say that this guy is an equal opportunity jerk." Usually, the people that use that phrase, and from what I have noticed in interviewing witnesses, the ones that say, he's a jerk to everyone. It's all the same, they tend to be white and male. So not always, but and then when I talk to the people that are Black and male or Latino, they see it as no, it's this person is there's a different, and we get back to. And then the question is it implicit bias? Is it has it crossed the line to explicit? I just worry that some of my clients and are too overly confident that they show that the person is a jerk to everyone and they'll get off. And then we mention the jury part. Yeah, right. Jury might say, "I had a bad boss. I didn't get to sue. Why am I sitting here in on jury duty for 3 weeks?" But they also might say, "Huh, this guy, treats everyone terribly, and he's gonna his company, they'll all get off, right? I said, it's not like a criminal case. They'll be found not liable efforts in their favor. They're being rewarded because in addition to being horrible to their black employees, they're terrible to their white employees, to their Asian employees. It's like it's gambling a lot on what will an EEOC investigator think. Well, and like I said, all they need to do is show a few comments, a
Yeah.
few stray comments. The last thing I'll say on that point is, and a lot of people that are truly this way, the angry,
Eric, your audio's cut down a little bit.
oh, sorry. Like, thank you for telling me. Let me try to fix that.
Just the last sentence.
Oh, great. I'm glad you told me. My microphone, I think I don't have with me today, so
Sorry.
I'm glad you mentioned. I was just saying that, if you're putting all your eggs in the basket that, a jury is going to say, oh, this person was rude to everyone. And again, I think I lost the train of thought. My concern was that when you shake the tree, eventually you'll find that person made some type of comment, some type of behaviors
Yeah.
that were different and abusive towards their gay employees, versus their straight. So I say, that maybe it's not the airtight sense that some of my clients think it is, and maybe it's not the, the fatalistic flaw that some plants might think it is. I don't know, right?
Yeah.
That's cool.
I definitely agree with you. I think that's very, very well said. Um, I know we're a little tight on time today.
Sure.
Do you want to share a little bit? I think you have a show that's going that has recently started up again, right?
Actually, it will be starting up soon. It's been on hiatus for longer than I care to admit. I do have a show on employment law today, and I think I even have a recording of us that I need to edit that I think did we do it back in October? I can't recall. Or did we plan to? Yeah, I have a show, and basically we talk about cutting edge novel employment law issues, just like Vince and I are doing today. It's been on hiatus only because I've been so busy, thankfully, with a lot of client work, a lot of litigation defense, a lot of compliance, a lot of drafting employee handbooks, a lot of training companies to follow the law. So I probably plan to start it up again. I'm going to record episodes in the summer, and it'll start rolling in the fall, September. So
Okay.
it'll be my own station, right? And my practice, again, is Sarver Law Firm PLC. Help companies to follow the law. And when I say companies, I don't mean just, well, actually, I don't mean big, giant. I mean, a small firm, Fortune 100s don't come to me. Small business, if you own a pizzeria or restaurant, if you own a marketing company or, a dental practice, I can help with the business law, the employment law, the contracts, the compliance, and the Department of Labor audits and defense. The DOL has been really firm these days on um, sort of thinking that everybody who works for anyone is a misclassified W-2. And I'm sometimes astounded at how much the DOL gets that wrong. I'm just like, wow, they hire people that are in the, field, they have their own LLC, they have lots of their own clients, they make their own schedule. There's a whole text chain asking, and then the DOL is like, nope, they're all misclassified employees, give us 75,000 hours.
I will to echo that. I will say that my firm maintains a list of certain.
Mhm.
I'm not going to say which state's Department of Labor,
Yes.
but certain Department of Labor employees in a given state who we know do not read the documents or the complaint or the filings. And we actually
Yes.
have a read to list where you have to read it to them.
Mhm.
And they will be so surprised when you read them. It's so disheartening to say, like, you've had this case for 9 months. You have not
Yes.
read the first paragraph. It's appalling. So Listen, everyone, when I have family, friends who need labor representation on the compliance or defense side, historically, I've always gone to Eric. I've never regretted it once, sincerely.
Mhm.
Um, his show is fantastic. I'm so excited for it to come back. It's it's deep. It's so some of you like the TikTok generation of employment attorneys, and they're swell, but sometimes they say things that only make sense in a 30-second soundbite.
Mm.
Eric will give you the actual lay of the land, and that is something you need if you're an employer. There's no question. You have to have a depth of understanding that you will not obtain from TikTok. You will obtain it from Eric's show without question. So I can't say enough. I can't wait to post the links to your show when it's live again. I was honored to record with you, and I'm excited. I'm excited it's back. It's awesome.
Documents, it's been really, like I said, been really busy these days, and it's just one of those things that it falls on the back burner because, as you and I know, doing employment law, practicing it, it's such a layered area of the law. And I want to thank you too, because your show is always very thoughtful, very thought-provoking, and I appreciate how we get into the law, but also we talk about the theory behind it, and then the consequences or the effects. That history of the non-competes, I was not aware of that. That it actually started out
Nor was
to
I.
protect and to get the have-nots into the have space, sort of social space by hiring outside the families of wealth, the monarchies and such. So that's interesting. I think more developments happen. I mean, you can't pick up your news app, whatever it might be, in a week without seeing employment law issues raised. So
Everybody works, but not
yeah.
everybody wins. You really have to stay on top of the law.
Mm.
It, it's so important.
And like I say, one last quick point about that, Vince. We're low on
Yeah.
time. There's a mug I love. It says, "Please do not mistake your Google search for my law degree." And they make them for doctors also. Don't mistake WebMD for a doctor's
Mhm.
opinion. I nothing against. I love outsourced fractional HR, and I have nothing against HR companies. That when they do, when a business, an employer, restaurant, a company, or an architecture firm, when an employer relies exclusively though on an online platform, you know, uh, just to make some money, it can be very catastrophic because that program won't evaluate in situations in if they do it in a vacuum. So you ask for a termination letter, they spit it out for you. Here you go. What state are you in? They might not ask you why are you terminating this person, and then when you tell them the reason, it could be like, whoa, hold on, this is a protected activity. You can't fire them for that. You've got to rethink this whole situation. So I think we as lawyers will ask those questions that an artificial intelligence based, you know, tech platform will not ask. So,
So many of my viewers, and I'm very lucky, my viewership allows me to look into the law, allows me to have conversations like this. But many of
mhm,
them have run afoul of these third-party tech solutions, the outsourced HR solutions,
yeah.
um, for a variety of different things. And when they describe what they're going through, the layers of paperwork and the delay that is
Mm,
generated by these third-party solutions, um, some of the biggest names are using them, the biggest warehouse companies, the biggest retailers,
yeah.
excuse me.
That's,
And
mhm,
it I don't understand. I think these third party solutions are supposed to limit litigation, but I actually view
mm,
them as generating litigation. The way they go about
yes.
things and the friction they create and the bad feelings, like I think they cause more litigation than they prevent.
100%. I think I told the story before, in line with what I was just saying, how a company, let's say, will say, "Hey, we got a termination letter from our online HR company. Can you look it over for me?" And I say, "Sure, okay." And I'm looking over, and it was this happened true story. It was a standard letter. Your Cobra, it starts with this date. Please return all company property, et cetera, et cetera. Your last paycheck is on, November 4th. I said, "Well, why are you firing this person anyway? It says insubordination," which you can tell the template typed in the word, insubordination. What's going on with this person? They said, "Oh, she was very difficult to work with." And they named a couple of work issues, okay, and tardiness and, not showing up, and they said, but the thing that got us is she's so insupportive. She's always trying to get people together to argue and organize for higher wages, trying to get raises, trying to get better meal breaks, saying the break room's not safe. And I'm like, whoa, whoa, this is protected activity under the whole National Labor Relations Act we talked about. You can't fire them for this, and nor should you. And if you have legitimate issues with their performance, let's deal with those and let's try to fix them. Maybe we can fix them. If we can't, let's document what's happening. Let's wait a little bit for cool heads to prevail, address their issues, and then we approach this. But the HR online platform didn't ask those questions. They typed in, I need a termination letter, for New York State, private
Yeah.
employer, and they just, the program said, here you go, and spit it out. So, it's very, I feel like there's no substitute for for you or for myself, for the
Yes.
human mind that thinks things through, that sees the big picture. If you have a small business, that's what we do for you. Yeah.
A lot of these solutions, to stress your point, I've seen one of the software solutions that one of these businesses uses. I've had
Mhm.
the opportunity to litigate, so I've seen a lot of screenshots. It
Yeah.
is HR by drop down menu,
Right.
and they have checklists, but the
Mm,
checklists do not convey a depth of knowledge. So it's things
mm,
like, did you investigate? Great. Investigate what? Like
right.
like you need to give this
Yeah.
person a little bit more. And they're doing
Yes.
drop down menus, picking multiple choice answers. Like, oh,
Mm,
yeah, there's a disability here. Do you have a doctor's note? Yes. Okay, great.
mm,
Um, are there accommodations requested? Yes.
mm,
Okay, great. Did you upload the accommodations? Yes. Okay,
mm,
great. I'm seeing a problem here. Who's going to make the decision? Who has discretion? Who's going to do a
right.
reasonable accommodation test, right? Like who, and
Yes.
that's you. That they're not going to do
Right.
that. They need
Right.
someone like you. Like there's just, I'm not deriding HR. There are amazing HR professionals. We've both worked with them.
Sure.
But I'll be frank, they probably don't work at a third party HR solution.
Right. Right. Exactly. The third party, the template, the robo, version, that the tech, or just it's not personalized enough, and it doesn't, like you said, the drop down menu is a great example. Employment law often cannot be summed up with a drop-down menu. I mean, as you've heard today in our discussions, right? There's no sort of yes or no question answer to the question, is employment at will, is it A, good, or B, bad, right? There's all kinds of gradations. And so I think
Yeah.
that's, what, like you and I, what we try to do, and you explain to employees their rights, and if they've been violated, you go after the company. I try to get the company as best I can to follow the law. And when they do, that's great. If they run afoul of it, or if they have someone there that did so by mistake, let's try to deal with it. If they're being sued, we'll try to defend them.
Mhm.
And this has been great. Thank you for having me on today. I really appreciate the chance to talk with you again. Yeah.
My pleasure. I can't. A life in employment law is a life making decisions in the gray,
Yes.
and the only guiding light is going to be a depth of experience such as your own. Employers need
Mhm.
you. I love I love knowing you're out there. I think it's
Thank you, Vince.
good for everyone. Eric, please consider coming on every quarter. We'd love to have you. The viewers
Thank
love
you.
you. Just
Mm-hmm.
you're a busy man, I know, but consider. Okay.
Will do, actually. That sounds like a great idea. Well, thank you, Vince. Thank you for having me. Thank you for, providing the platform, and for all you do, with heart and soul and passion, out there. We have good people on both sides of this, on the litigation right front. And then there are some that are not so good on both sides of the on the employer-employee litigation. So it's always a pleasure to meet, fellow gentlemen, fellow gentle person, I should say, because there are gentle ladies out there and non-binary folks who do this very, very well also. But thank you for having me on today. It was a pleasure meeting you.
Thank you so much, everybody.
Yeah,
All of Eric's links are going to be down below. Can't say
yeah.
enough good about him. Tremendous,
Thank
Eric.
you.
Thank you again. Have a great day. Have a great weekend.
You too, my friend. Thank you so much. Have a great day.
Got it. Take care.